In this video we'll highlight two cases that demonstrate specialist advice is essential when it comes to commercial leases, and especially the break clauses of those leases. Now, something that came up in the Supreme Court was a case involving Marks and Spencer. Now, the tenant exercised a valid break clause to release themselves early from the release. Now, unfortunately, the tenant had already paid rent in advance, which basically extended for a period beyond the break date. Now, the judge in this case ruled that as the lease did not clearly state otherwise, the tenant was not entitled to a refund of the overpaid rent. So because the rent was being paid in advance, the judge ruled, because it wasn't specified in the break clause, that they weren't entitled to a refund of the overpaid rent. Now, this basically highlights why you have to pay very, very close attention to the details of any break clause. Now, in the break clause, flexibility for you as a tenant is the key, and ensuring nothing prevents you from utilizing the break clause in this way is absolutely paramount. Now, in this case, some simple additional wording to allow for the rent to be repayable in these circumstances would have saved Marks and Spencer's an absolutely substantial sum. Now, in the second judgment, we have to make sure that in leases that the named landlord is the owner. In this particular case, the High Court considered the position in a case where the farm tenant had no right to possession of the land, as the true owner was not named in the lease. So what happened was the company was named as the landlord in the lease, but the company didn't have the power to grant, as it was not the true owner of the land. Now, this is very strange. It's an unusual case. The landowner was the company director who had signed the lease, but he wasn't named as the owner in the document. So once again, it's all fine detail. As the company was named as the owner rather than the director, the tenant may have had to vacate the property at short notice. Now, these minor details could have a major impact on this particular tenant, and of course, if it ever happens to you, it could have a major impact on you too. I guess basically the summary on this is you must always get a solicitor to check the detailed commercial lease wording, and these two cases highlight two very simple errors which were made in the commercial leases and in the break clause. So if you want a review of your existing lease, or a meeting about renewing your lease and changes you might want to make, or even if you're thinking about signing a release, then please call Martin Reynolds at Barrett and Co. The number is there on the screen, and the email address for Martin is there. Thank you very much for watching. Remember, don't rush into a release. It may well be enticing to get things completed quickly, but in your enthusiasm, mistakes can all too often be made which you might regret later. So it's better to be well prepared in negotiations, and you can do this by taking early advice from Martin.